So I want to talk about hearsay and how to deal with hearsay that has become much, much more difficult since the People versus Sanchez case came down in 2016. So let's talk about hearsay, because at trial is when hearsay becomes relevant, right? Hearsay objections not even made in a deposition. Of course, you can get hearsay because it's a discovery tool. And hearsay is many times a great information. It just has to meet certain criteria to become admissible in court. And it used to be, before the People versus Sanchez came down in 2016, that you could have a designated expert not only review hearsay, but talk about hearsay. And the rule was, if it's reliable hearsay, they could talk about it. And I remember when I first started trying cases on my own, when I opened my own firm, and I would try as many as like 10, 11 a year, I could get involved in a case that was totally bungled a week before trial. I had a designated expert, and they could talk about everything in the records and everything they saw and put it all together for me kind of on the fly. It was great. Well, in 2016, in the criminal arena, the case People versus Sanchez came down, and it has now been applied in civil cases and has changed the landscape, changed how you have to prepare for trial. People versus Sanchez had an expert, and that expert in the criminal case was a gang expert. And like we had been doing forever, that gang expert said, hey, I read this file, and the defendant is a known gang member, and he's a member of the following gang. And he got that information from documents that he read that was hearsay. In People versus Sanchez, the courts came down and said, well, that expert can have an opinion about certain things. They can say, in my opinion, he was a gang member based on everything I've looked at or reviewed or something like that. But he can't say what was in a hearsay document or repeat what was a hearsay statement. A couple years later, that started being applied, kind of got on the radar of the civil courts. Well, that has now changed the landscape, right? Because your expert can no longer repeat hearsay to a jury unless that statement has met the hearsay exceptions, foundation, admissibility, etc. Well, let me give you some examples of how this has been applied. It used to be that you could have an accident reconstructionist, and he could testify that, in my opinion, the speed was 30 miles an hour before the impact based on the skid marks. Well, how long were the skid marks? Well, they were 45 feet. Well, if he got that 45 feet from the measurements in the police report, that's inadmissible hearsay unless you call the police officer to foundation for that hearsay. So now you can't just have your accident reconstructionist. You got to call the police officer before, or take that police officer's deposition to establish the foundation. A doctor wants to talk about what the MRI readings were. Well, if he's using a MRI report rather than looking at the scans himself or herself, he can't say what's in the report. And if that's the only place he finds a 5-6 millimeter bulge at C5-6, then all he can say is based on what he knows independently, but he can't say there was an MRI at such and such a date and it found this, because that's inadmissible hearsay. So now you have to either call that radiologist, or you have to take that radiologist's deposition, or you have to agree to waive the Sanchez rules for particular things of evidence. So now, how has that changed the landscape? Well, I've been involved in a trial as late as the night before we start. Now Sanchez. Hey, Mike, we got a trial in a month. We got a trial in 3 weeks. You want to come in? Absolutely. I'm ready to roll. But have you taken the treating physician's depositions to establish what they're doing and what they said so your expert can rely on it? If you haven't, then I need to either get a waiver of the Sanchez from the defense, which they'll never do, or now I have to call all the treating physicians or try to depose them if I still have time so that I can play those snippets before I call the expert so I can lay foundation. Okay? Now, how do you use this as a plaintiff's lawyer as a sword? Because you can see all the shields that the defense is using it for. Now, your 1 week trial becomes 2 weeks if they make you call every treating physician. So the first thing is you want to know what Sanchez is so that you can anticipate the need for that foundation and ask 6-8 months before, are we willing to waive Sanchez? Because if you ask it 35 days before trial, the answer is going to be no. But if you know enough to ask early enough, the other side is probably going to say, well, I can't get an unfair advantage, and it's easier on both sides to not have to call all these people. So maybe we'll waive Sanchez. But if they won't, you want to know that with enough time to take the various treating physicians, the witnesses, maybe the police officer, maybe the videographer or the camera, surveillance camera, et cetera, so that you maybe can cut that down and play 5 minutes of a snippet, 10 minutes of a snippet to satisfy the judge, rather than call 20 more witnesses that makes your 1.5 week trial 2.5 weeks. But now let's talk about, how do you use it as a sword? Well, it used to be that the defense experts, and I hate calling them experts, I know they're smart and I know that they know what they're doing in medicine, but I don't think they're experts other than experts at cheating people out of just recovery. But they would come in and they would say, oh, well, the plaintiff didn't complain of X, Y, or Z, or the plaintiff said this at the ER. And see, that means that they couldn't have been hurt. That means that they didn't have this. That means if they said this, it means not this. Well, wait a minute. That's a hearsay document. Wait a minute. How do you know that that's a party admission? How do you know that's not the nurse or a paramedic writing down something that they heard from another person? So now that defense expert can't come into court and say, well, it was a plaintiff who complained about X, Y, and Z at the scene, unless the defense has established that foundation so that it no longer is inadmissible hearsay. So when the defense asks you to waive Sanchez, then you also need to watch out. And well, if this is a blanket request, maybe I need to go back. And most importantly, I've seen in the early stages where you got paramedics, ER doctors, ER nurses, you don't know who said what, you don't know about loss of consciousness. If they denied loss of consciousness, maybe that's not a denial by the plaintiff. Maybe it's the paramedic telling the nurse who writes in there no loss of consciousness. And then the defense expert tries to say, you see, the plaintiff said there was no loss of consciousness. Well, wait a minute, that's a hearsay document. Wait a minute, you can't say that. At most, you can say, well, I reviewed all the records and my opinion is that they didn't lose consciousness, right? That's maybe as far as they could go. And I did a video maybe a week and a half ago about a recent case, the estate of Letts, where the judge properly excluded an expert completely because their entire testimony, which turned out to be correct, but it was based on reading a hearsay document, and the lawyers had not provided the sufficient foundation for that hearsay. And so even though the guy said, I forget exactly what it was, the number is X and it was correct, the way he knew that number was from reading a out-of-court statement, hearsay document, that if they had taken the deposition and gotten that foundation, then that expert would have been able to testify. And so when I talk about People versus Sanchez, to a lawyer and that lawyer doesn't know what Sanchez is, when I talk to a defense lawyer and I'm like, hey, you want to waive People versus Sanchez? And they go, let me talk to my partner. And I realize they don't know what Sanchez is. Then that tells me the level of their experience. For years, I would mention it to judges and they didn't know what to do with it. Now I think it's kind of been long enough. But if you need any information about this, if you need briefing, if you need to know tricks and trades to get around Sanchez, to get that radiology report in most of the way without getting the actual statement, there are tricks and trades that I'm happy to share that I've written about. You just reach out. My information is in my bio. It's in the video description, and I'm happy to help in whatever way I can.